She has practiced in the field of intellectual property, corporate and commercial law, and civil litigation. Ms. Rees holds a master's degree in intellectual property from King's College in London. And she has served on several state boards and cabinet appointed committees. At present, she is the Deputy Controller of the Intellectual Property Office of the Ministry of Legal Affairs. Ms. Rees.
Thank you. Good morning.
Good morning.
San Fernando, are you hearing me? Shabramas?
Yes, I'm hearing you.
Okay, Point Lisa?
Yes.
Great. San Fernando once again? Silence.
San Fernando, are you hearing us properly? Anyone from San Fernando?
Okay, fine. Okay, great. Thank you. The title of the presentation is Reprography under the Copyright Act 1997. Copyright, as the name suggests, it is the exclusive right of the author of the work to copy the work and to control the copying of the work by third parties. It is the intellectual property right that subsists in original, literary, artistic, musical, and dramatic works, including works of mass, databases, translations, and computer programs. Trinidad and Tobago's legislation is unique in that it is the only legislation in the world that actually provides copyright protection for works of mass. In order for a work to be protected by copyright, it has to be original, namely the author's own intellectual creation. Under Section 5 of the Copyright Act 1997, there is a long list of various goods to which copyright applies. These include books, pamphlets, articles, speeches, lectures, dramatic works, choreographed works, and other works created for stage productions, musical works, audiovisual works, works of architecture, works of drawing, painting, sculpture, and photographic works. Also works of applied art, maps, plans, sketches, and three-dimensional works relating to geography, topography, architecture, or science. There are certain things that are excluded from copyright, and these are ideas, procedures, systems, methods of operation, and generally these areas fall into other categories of IP, intellectual property, and then you also have official texts of a legislative, administrative, or legal nature. These are not protected by copyright. Political speeches and speeches delivered in the course of legal proceedings, they are not protected by copyright. However, the collection of texts or speeches may be protected by copyright if they are original by reason of the selection, coordination, or arrangement of their contents. An example of this would be speeches, Dr. Eric Williams' speeches. Copyright is a property right. It's a form of intangible property. The right of ownership to the tangible medium, for example, a CD, a book, or a DVD. It doesn't vest the use of tangible medium with copyright. So, for example, you have a book, you have a CD. You, as the owner of the tangible book or CD, you're not entitled to make multiple copies of the particular book or CD. Original works are protected as soon as they're created pursuant to the Berne Convention, to which Trinidad and Tobago is a party. Therefore, there is no registration required for copyright to subsist in an original work. You don't need to come to the Intellectual Property Office to register your copyright in order for copyright to subsist. Generally, many times what you would see, it would be the little c in the circle, followed by the name of the organization, or for example, the author, followed outright all rights reserved. This may take different forms. For example, in a book, they may have no part of this book may be reproduced without the permission, for example, of the publishing company in any form or medium. The general rule is that copyright vests for the life of the author plus 50 years. And for collected works and audiovisual works, the period of protection is 75 years from the date on which the work was first published. After copyright expires, the work is deemed to be in the public domain. The general rule is that the original owner of copyright is the person who created the work, except where the work is created in the course of employment, the copyright owner is deemed to be the employer. If a work or sound recording is made by or under the direction or control of the government, then copyright or related rights belong to the state. Our governing law is contained in the Copyright Act number 8 of 1997, and this may be viewed online at the Legal Affairs website, which is legalaffairs.gov.tt, or the World Intellectual Property Organization's website, which is wipo.int/CLEA. But the easiest source to find it would be legalaffairs.gov.tt. The economic rights are the commercial rights of the copyright owner. This gives the copyright owner the exclusive right to do, authorize, or prohibit the reproduction, translation, adaptation, arrangement, or other transformation of the work. Other economic rights include distribution, importation, public display of the original or a copy of the work, public performance, broadcasting, communication to the public of the work. The moral rights are the rights of personality of the author. The author has the right to be identified as the author of the work, not to have their name indicated on the work if they so desire, to use a pseudonym, and to object to any derogatory treatment of the work. Related rights are proprietary rights that subsist in performances, sound recordings, and broadcasts. Reprographic reproduction is copying by various means, such as photocopiers, fax machines, computers, scanners, printers, stencil, and microfilm. There are certain limited exceptions to copyright, and this pertains to educational purposes for teaching, reprographic reproduction by libraries and archives, quotation, news reporting, reproduction of a single copy of a computer program by the lawful owner, and importation for personal use of up to 3 copies of a work. Insofar as it pertains in particular to educational purposes, reprographic reproduction, quotations, news reporting, the Act says a short part of the work. Now, the exceptions is contained in sections 9 to 17 of the Act, and under section 9.1 it says a single copy of a work may be made for one's private personal purposes. However, under section 9.2b, it is expressly stated that this exception does not extend to the reprographic reproduction of the whole or a substantial part of a book or of a musical work in the form of a notation. In all other circumstances, the copyright owner's permission is required. As you look through the sections between 9 to 17, it constantly refers to a short part of the work, but of course there's no definition of what constitutes a short part. The general standard for short part is that it should not be more than 10% of the work. And of course, under section 9.1, even though it says that a single copy of a work may be made for one's private personal purposes, it continues to state that that single copy does not include the copy of an entire book for your private personal purposes. Under section 11.1a, reproduction of a short part of a published work for teaching purposes by way of illustration, in writing, or sound or visual recordings, provided that such reproduction is compatible with fair dealing and doesn't exceed the extent justified by the purpose. When they refer to fair dealing, generally it goes back to the exceptions in terms of quotation, criticism, news reporting, and once again it's only a short part of the work. Under section 11(1)(b), the exception also extends to reprographic reproduction for face-to-face teaching in educational institutions of published articles, short works, or short extracts of works, provided that the act of reproduction is isolated and there is no collective license available under which the reproduction may be made. So in essence, the cumulative effect of this particular exception is that it has to be done for face-to-face teaching in educational institutions. The act of reproduction has to be isolated, and there is no collective license available under which the reproduction may be made. So therefore, if there is a collective license under which the reproduction may be made, this particular exception no longer applies. Also, you have an exception for reproduction by libraries and archives. A single copy of published articles, short works, and short extracts of works may be made by a library or archive at the request of a natural person, provided that the copy is for study, scholarship, or private research. The act of reproduction is an isolated case, and there is no collective license available, or where the copy is made to replace or preserve a copy, and it is impossible to obtain a copy under reasonable conditions, and the act of reproduction is isolated. So this particular exception applies to reproduction by libraries for the purposes of study, scholarship, or private research. The act of reproduction is an isolated case, and there is no collective license available. If once again a collective license is available, this particular exception does not apply. Practical measures for librarians. You should ensure that a license has been obtained from the Collective Management Organization for Reprographic Reproduction. In Trinidad and Tobago, it's called the Trinidad and Tobago Reprographic Rights Organization. Another issue is that you should also use a reproduction application form that contains all the pertinent data to ensure compliance with Section 12 of the Copyright Act 1997. This here is a sample of a reproduction application form that is used by the National Archives. It contains data in terms of the person's name, address, the date, the name of the work that is being copied. Also, in relation to it, you also need to include the purpose for which the copies are being made, and also the number of copies, in particular the pages, should be noted. This is also another sample form. This particular form has more detail because there's a section that actually deals with the purpose of research, the type of research. The information in the form should be entered into a computerized database so that one may track easily whether or not the work is being copied repeatedly. Notices should be placed on the form and in prominent places in search rooms and near photocopying machines, outlining what may be copied legally and the penalties for copyright infringement. And practically also, photocopying machines should be placed in prominent places where copying may be monitored. Copyright infringement arises when a person exercises any of the copyright owner's rights for which the copyright owner's permission is required. Some common examples include plagiarism, the photocopying of books for sale or distribution, reprinting a textbook without the permission of the copyright owner, making a work available on the internet or intranet without the copyright owner's permission, if such use is not covered by the terms of the license, playing music at effect without a copyright license, or publicly performing a play without the writer's permission. The penalties, it's $250,000, maximum penalty of $250,000 or 10 years imprisonment. You also have injunctions and seizure, forfeiture, and destruction of all infringing copies. Libraries provide valuable sources of information to the public. The public's right to access to information has to be balanced against the proprietary rights in the nature of copyright that subsists in the work for the benefit of the copyright owner. The acquisition of licenses from the Trinidad and Tobago Reprographic Rights Organization will facilitate legitimate access for the reprographic reproduction of works. Prior to preparing the presentation, I received a number of questions which various people had on the issue of copyright in general. And I would just begin to address some of them. Some of the issues that were raised were in relation to the placing of copyright works on Blackboard and on Moodle, for example. One of the basic things that you have to remember is that notwithstanding the fact that the medium has changed, that you've gone electronic, the same copyright rules apply in the digital environment. It does not shift, it does not change. So where it is that the Act provides that only short parts of the work may be reproduced, that still applies also in the digital arena. It doesn't change, it doesn't become the wild west in that regard. So fundamentally, once it is that you're going beyond reproducing a short part of the work, which as I said is no more than 10%, you need to actually have the permission of the copyright owner. Practically and logistically, it's generally impossible for everybody to go around and find all the different rights holders and stuff. And this is where the license from the collective management organization, in this case the Trinidad and Tobago Reprographic Rights Organization, comes in, because they would actually give you a license to deal with reproduction in various forms, whether it is in hard copy or in electronic environments, and that will actually prescribe the limits vis-a-vis what it is that you may or you may not copy. Another issue that was raised was to what extent can the university claim ownership of your work? In one of the previous slides, I indicated that when a work is created in the course of employment, in the context of the employees of the university, the copyright ownership actually belongs to the employer. In the context, I know the University of Trinidad and Tobago has an intellectual property policy, and I was actually searching on the internet for the policy. It doesn't have it.
It's a draft.
It's a draft?
Yeah.
Okay, alright, fine. In the context of the university, you have, once this is created in the course of employment, it belongs to the employer. One of the things that will have to be considered, and the university has to look the extent to which the IP policy will cover in particular PhD students and MPhil students, because the work that arises based on their theses and the papers that are prepared, there may be some degree of intellectual property protection and stuff arising therefrom. It may not only arise in the realm of copyright, but you may have inventions and other forms of IP arising from it. There was a question raised in relation to how can you protect your designs or creations. In essence, you have to register it. The government office that deals with it is the Intellectual Property Office of the Ministry of Legal Affairs, and we are located at 3rd floor Capital Plaza, 1113 Frederick Street, Port of Spain. There's a process by which it is that you register the designs accordingly, and this would be from the industrial design perspective, and also, for example, the trademark, which is the particular name under which you actually sell whatever it is you created, or depending on what it is that you created, there may be a patent involved or some other aspect of intellectual property. The other areas of intellectual property, other than copyright and related rights, there is registration, but as I said before, there's no registration in relation to copyright. in relation to the playing of music, what happens is that once it is that you play music outside the members of your family, is deemed to be a public performance. And once there is a public performance, the permission of the copyright owner is required. The permission of the copyright owner has to be obtained from one of the collective management organizations that actually grants licenses for the playing of music.
Can I interrupt?
Yeah.
It's a family. Suppose
Outside.
Yes,
Of the
outside. That means
yeah.
neighbors and so on come to your house and you play the music.
Strictly speaking, they say family and close friends. So once you go beyond that, you're supposed to have a license. That's what the act says. A public performance arises thereafter. So that strictly speaking, a license is required, and the entities that grant the licenses, there are 3 collecting societies that deal with playing of music in Trinidad and Tobago right now. So that you will have to check with them in relation to those licenses. Okay. The 3 are, well, there's the Copyright Music Organization of Trinidad and Tobago, which is COT. There's the Trinidad and Tobago Copyright Collection Organization. And then there's another one, the acronym is AWESOM, which means Advancing Writers, Entertainers, Singers on Music Endeavors. So that there are 3 organizations that deal with the issuing of licenses in relation to musical use. Now I will take questions from everyone, because I think I more or less covered some of the questions that came previously.